statute. Please be seated.
Good morning.
Good morning.
How's everyone doing today?
Very well.
Good. We're having really nice weather. Maybe not yesterday. Seems like it's low humidity today. So welcome to the First District Court of Appeals. Today is Tuesday, July 25th. We have 4 cases on the docket this morning. 2 have submitted on the briefs and 2 will be arguing today. The first case that we have is State of Ohio versus Rath, case number C220477. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Brian Perkins on behalf of Appellant Christopher Worth, ready to proceed.
Good morning.
Sean Donovan on behalf of the state, Your Honor, ready to proceed.
Good morning. And then we have State of Ohio versus Wheeler. This case has submitted on the briefs. This is cases number C220490 and 491. The third case we have is State of Ohio versus Dupree, case number C220560. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honors. Laura Peters and Spencer Hetner for the appellant. Spencer will be due the oral argument today.
Okay. So is Spencer an intern or a...
He is a licensed attorney.
Okay, all righty.
He's an attorney with our office.
Okay, thank you.
Good morning, Your Honor. Danielle Ferris for the city. I will be doing the oral argument.
Thank you. All righty. And the fourth case we have is case number C220643644, Lisa A. Morrison versus Frank S. Walters, and this case has also submitted on the briefs. Attorney Rath, whenever you're ready. I'm sorry, Attorney Perkins.
Good morning, Your Honor. Brian Perkins
Good
on behalf of
morning.
Mr. Worth.
Would you like to reserve time?
Yes, Your Honor, if I could reserve 5 minutes for rebuttal.
Okay.
Your Honor, what I think is important in this case is that not only the argument, the evidence, the line of questioning, the opinion of the police officer, that whole line that was presented by the prosecutor in this case, not only reinstates or requires a duty to retreat, which I believe is wholly improper, but it's as if it creates this duty to avoid trouble, to not go anywhere near where there's danger, even if you are on your own property. And I think that is a misstatement of the stand your ground law, which allows you to, if not retreat.
So are you defining the property then to include the yard?
Yes.
For the
Yes.
purposes
Now,
of stand?
I understand for the Castle Doctrine that would be questionable, that would include the house and so forth. But yes, his property would include the yard. And what's important is that Mr. Worth never, ever leaves his property. The state makes an argument that by him going outside, he's essentially being the aggressor. He's at fault in this situation. But if you watch the video, there's no doubt that Miss Estes is the trespasser here. There's no doubt that Miss Estes is coming.
I mean, she's trespassing, and like I agree with you there, but she's unarmed, and I'm concerned that the proposition you're advancing would just give people license to go around shooting people that might be on their property.
But I think the distinction with that, Your Honor, is that Mr. Worth did not know she was unarmed. And in fact, if you watch the video, she constantly has her hand in her pocket, and she's making threats to stab Mr. Worth and his mother. So I think a reasonable person in that situation where she's digging in her pocket, has her hand in the pocket, has her hand concealed, making those threats, the combination of that, I think, would leave a reasonable person to the belief
but I think
that she was armed.
At the time that he actually pulled the trigger, her hands were out of her pockets.
I don't believe
No,
that.
it was. I checked. I watched it probably 5 times to check that. Her hands, she had taken her hands out of her pockets when he pulled the trigger.
Well, but if you look, if you watch it, he's on his property. He doesn't even have his gun drawn at that point in time, and she lunges at him.
I know.
And then he backs up. And I would submit to the court, if her hand is out of the pocket, he is reacting in a split second to a situation of there had been minutes going by where she's making these threats, where she has her hands in her pocket, where she's reaching for it. In fact, her hand is definitely in her pocket when she's lunging towards him. So again, he makes a split-second decision to use force to protect his mother. But I
Don't you
don't.
think here that, so he testified that she was making threats? And that was, on the 911 call, his mother said that she was making threats. She testified that she made no threats at all,
Correct.
correct?
Correct.
So wouldn't that show that the trier of fact believed her over him? And especially since he lied about certain things to the police. For example, he lied about her kicking on the door and banging on the door and seeing a knife handle.
Well, I don't think he necessarily lied about that. I think that was his perception. Again, I'm not claiming she was hitting on the door, but if you watch the video, she is pointing her finger at the door, she's yelling, she's screaming. If you're on the inside of the house, from his perspective, I think you could certainly believe that she is hitting the door. So I don't think that's necessarily.
My point here is, it seems to me that, this trial, the triers of fact obviously believed her over him.
Well, not necessarily, because with the argument that was made made by the prosecutor that essentially he's an aggressor, he's coming out. That doesn't. We don't know why the jury made the decision that they did, but we do know that, at least in my opinion, there was an improper argument made to this jury that he should have stayed inside. He shouldn't have come outside. He was the aggressor when he came out. So whether the jury believed her about the threats or whether they believed him but didn't believe him about the threats, I don't think is the deciding issue.
Who is the aggressor is a relevant consideration even under the stand your ground law, because you have the privilege to stand your ground, but that does not give you the privilege to commence the affray and to be an aggressor.
Correct. And if you look at the video, if the court wants to hold, as the prosecutor argued, that by a homeowner walking to the edge of their property line with a gun in their pocket after being confronted somebody, does that make him an aggressor? Absolutely, absolutely not. That would create certainly dangerous precedents that anytime a homeowner goes out in their yard when there's somebody there, that they are becoming the aggressor. He never, if you watch the video, he never aggresses
Part of
towards
the
her.
state's argument is that there was an alternative. So is it your position that there wasn't an alternative, or is it your position that the alternative should not have been considered?
There was an alternative, but it should not have been considered, and it should not have been argued that by him not taking advantage of that alternative, he was the aggressor.
And can you cite to any case to support that proposition?
Yes, there is many cases that I cited in my reply brief that address the issue where, if there are alternatives, for instance, in going way back, Thompson versus United States, where it was argued that the person was at fault in the situation because they rode by an area where they had been previously threatened. The Supreme Court said, no, that's not, if he has a legal right to be there, you can't consider that as provoking the situation. State versus Gillespie, which I know isn't exactly on point, because the issue in that case was whether there should be a self-defense instruction given, but the Court of Appeals in that case, which was out of the 2nd District, indicated that the Gillespie was not at fault in the situation because even though he got a shotgun and went after looking for someone who had stolen from him and brought that person back to his house, they indicated that did not create fault in the situation. Rather, it's not whether the person played any role in it or whether there was some alternative that this person could have engaged in, but whether they were at fault in the situation by engaging in such wrongful conduct towards the assailant that the assailant was provoked to attack the defendant. Again, in this case, the fact that there was an alternative, yes, he could have stayed in the house and none of this.
So you want us to view it from the moment that, that the trigger was pulled or what immediately preceded that, rather than looking at the totality of what it was that occurred? It sounds like that's the essence of what you're asking for.
Yes, because I would say that if you, again, watching the video, when she goes to the sidewalk, things are kind of over from what initially happened. I mean, the threats were still there and so forth. However, when he walks out of the house and walks to the edge of his property, I think that's what you have to look for. Is he engaging in such wrongful conduct towards Miss Estes that he provokes her violent response? And the answer to that is no.
What was her violent response?
I'm sorry.
What was her violent response?
She lunges onto his property.
But where was the violence?
I would submit that threatening somebody, lunging onto their property after
If you want us to look at that moment, then what was her violent response at that moment?
Correct.
If you're saying don't look at everything, then we shouldn't
Well,
be
yeah.
looking at everything for her either.
I think you should still look at everything, but I think what needs to be the focal point is that moment when Mr. Worth and his mother walk out to the edge of their property. They stay on their property. They're not engaging in any illegal activity. They're where they have a legal right to be. And then she, with her hand in her pocket, again, starts this whole thing and lunges. Again, it would be disingenuous to suggest that she's not trying to make them believe that she has a weapon in her pocket and she can attack them. And that's what the court should look at that point in time, is that they did nothing wrong. They're not at that fault. And in fact,
So if I'm sitting in my yard and I have a sidewalk by the yard and people are walking by and they have their hands in their pocket and they yell at me, they look funny, like whatever, like, do I have a privilege to shoot them? I mean, I'm concerned about, like, what is the rule that you're advocating? And you seem to be saying that as long as I'm on my property, if I subjectively feel that someone is a threat to me, I can shoot them.
I would say that if that is a legitimate subjective belief based on and it's objective facts as well, I would say that is the case. Now, if someone just has their hands in their pocket.
And it sounds like you're saying at that moment, the duty to retreat is inconsequential, should not be considered.
Absolutely. And if you watch the video, in fact, he even does retreat. He's trying to get away from her. And it's not until the moment that he attacks goes to attack his mother that's when he draws his gun, and that's when he acts in self-defense. So I understand.
I want to make sure that I understand, because it seems like what you're also saying is that the use of deadly force trumps the duty to retreat, and that or makes it non-existent in some ways, that somehow the use of deadly force is okay regardless of the duty to retreat.
Correct. I mean, I think that's what the law indicates, is that if you're using force in self-defense, the jury should not consider whether you had the ability to retreat from that situation or not. And they should not consider that. Whereas in this case, that was the state's whole argument, is that he should have stayed inside. He shouldn't have come outside. He became the aggressor when, in fact, he never left his property. I don't believe that he can be considered at fault in that situation.
So unless there's any other questions from the panel, I'll reserve you 5 minutes.
Thank you, Your Honors.
Morning, Your Honors.
Good morning.
There's an awful lot to unpack, and I promise I'll try and get to.
Why don't you start with the duty to retreat? Do you mind?
Yes, ma'am, absolutely. As the state reiterated over and over and again, as the jury was instructed, there was no duty to retreat. But by the same token, as the trial court opined when they were discussing this, is there a right to advance? And I think that that's part of the concern that Judge Bergeron is mentioning, and part of the argument that we made, that while there is a prohibition on entertaining or arguing the duty to retreat, it is not a blanket prohibition. It doesn't mean that you can't use it for any instance. And the evaluation here has to be the totality of the circumstance. It has to incorporate everything that happened on that day. It can't be just that moment. That's not what the law says, and that's not what's appropriate here. What the evidence shows
What you're
is,
looking at is whether the accused basically upped the ante in some ways.
certainly, yes. And at its core, what we have here is Mr. Worth shot an unarmed woman. Now, the question primarily before the jury was credibility. He says she threatened him. He says that she repeatedly threatened to stick him, that she repeatedly indicated that she had a knife.
And he also focused on her hand in the pocket.
Yes, ma'am.
And sort of like the mannerism associated with that, the demeanor mannerism with that.
Absolutely. At different times, he says that it's inconsistent as to, the hands in the pocket the entire time, but he doesn't think it's enough of a threat, and this goes towards his right to advance. It's not enough of a threat that he doesn't walk up to within 5 feet of her. It's clear that, and he makes much of the fact that he has a legal right to be on his property. Absolutely, he does, for sure. April had a legal right at that point to be on the sidewalk. So they both have a legal right to be where they are. Does his legal right trump hers in that situation? What's also clear is that as he and his mother, this is a very heated exchange. This is very, tempers are flaring. There's absolutely no doubt about that. And April freely admitted that she was angry. She believed that he had molested her daughter, and she was mad. She's standing there, they're talking back and forth. As Mr. Worth, who she knows he's got a gun. He's been brandishing it around, he's been holding it throughout the entire time. She knows it's in his pocket. They are now approaching her. And as they get close, you can see on the video, she steps back. She is now readying herself for a fight. Yes, she lunges at him. Absolutely. There's a single lunge.
So you're saying it
towards
comes down to a credibility determination by the trier of fact?
Absolutely. And Mr. Worth gave the jury more than enough evidence that he wasn't credible and that he was...
What was the mother's testimony about any sort of knife or threat on that?
The mother gave generalized testimony as to threats to harm, threats to kill. She certainly testified to that. She did not make specific statements about a knife. And that's one of the things that we think argues against his being found credible, is that according to him, repeatedly, but she doesn't say anything about a knife. She doesn't talk about that. She talks about a generalized threat.
Should the shirt, I'm sorry, go ahead.
And he told the police officers that he saw a knife, correct? And
He
there
said that.
was no weapon anywhere.
That is correct, ma'am. He told the police that he saw the handle of a knife in her pocket. No knife was recovered from her or from the vehicle or
Right.
from her friend who was there with her. That is correct, ma'am.
Okay.
And that's one of the things that we point to, the different things that he said in trying to make himself look better and look more reasonable.
And also, when his mother called 911, she told the operator, what did she tell them exactly about weapons? I mean, I think she asked if there were weapons.
She did not believe so at that time.
Okay.
There was a statement as to that. Once again, there's a lot going on in there, but that was the testimony that was elicited at trial as well, that there was statements as to that.
Should the jury have considered whether she had an alternative, whether she could have moved away from the situation?
I think that's certainly appropriate in terms of when she's at the door and everything like that. Yeah, not only did she have an alternative, she had an obligation to retreat. She's absolutely they have asked her to leave. At that point, she's initially refusing to leave. She's a trespasser. She's in the wrong at that point. The police have been called. They're on their way. She then complies. Now, it's allowed compliance. They're still yelling back and forth, but she complies and then retreats out to the sidewalk and is standing on the sidewalk when they re-engage her. The threat has been abated now. Now they're both in a position. I think that it's possible to say, you know, if she had shot him, we would have been in a situation, you know, saying that she was where she had a legal right to be on that sidewalk and she didn't have a duty to retreat. Because she was shot, there was that availability, and I think that that can kind of go into the reasonableness of her actions and everything like that. But also, I would argue that
I mean, it sounds like you're saying if she had shot that she may have been equally at fault and would be facing the same charge and the same outcome.
I think that, yeah, if she re-engages and everything like that, that, you know, and if the situation's completely reversed and she's saying that he's making the threats and things like that, you know, I probably shouldn't have brought up the hypothetical in that case. But
Yeah, because I think it casts some issues
in terms
here.
of the duty to retreat, I mean, we've got to flip an awful lot of facts in order for that analogy. But in terms of, could the jury have entertained her ability to retreat? I think that, yes, I think that that is a factor that can be taken into account there. She did not use force, unless we consider the lunge to back the two of them off. She didn't use any force.
Well,
So
I think,
we weren't
but
in that-
again, the use of force wasn't the only thing before the jury. It was basically her mannerisms and her demeanor, and with regard to her hand in the pocket and, you know, what was going on in there, what he might have perceived that to be.
Absolutely. And in terms of, but once again, his perception on that comes down to the jury's credibility determination and the ample evidence that he gave them to not believe him. I would also take, you know, ask the court to watch. Mr. Perkins just said that he starts to draw only after April lunges at his mother. I don't believe that's what the video shows. I think the video shows that when she lunges towards him, he steps back and immediately starts trying to draw the pistol at the same time. She is then, you know, making the lunge at mom. And then when she sees the weapon, she starts going back. That's when he shoots her twice. And then as she's on the ground, he says that he pushed her down. He kicks her in the chest. He keeps saying that he keeps trying to present that it was a reasonable, rational decision, and ignores all the evidence that he was angry. He was furious at that moment, and he was furious at her, and that drove his actions. And I think
They were
that,
both furious.
absolutely, absolutely. But only one of them shot an unarmed
Right,
person.
and they both had opportunities to retreat. It's
Yes, ma'am. And he didn't have, you know, we agree, and the prosecutor made the statement to say that our entire argument without citation to that, and that's a point that I want to make. I did not move to strike the reply brief because there were certain sections of it that did properly respond to arguments that I had made. However, there's a large portion of it that is providing citations that were not initially provided, that's raising new arguments. To that extent, the court is well aware of what's proper for a reply brief and what isn't. I would ask you to ignore the retroactive arguments that were made that I didn't have an opportunity to respond to in terms of that.
I want to clarify something here.
Yes, ma'am.
So the statute forbids the trier of fact from considering the duty to retreat, but only for one part of the self-defense framework, correct? Only if it was reasonable. Is that correct?
The statute says that, and I'd have to grab to have the exact language, but it's the necessity of the use of force is that it can't be entertained. And it makes a specific mention of what it cannot be. And we would argue that it can be entertained, as Judge Bergeron was pointing out, in terms of whether or not you're the initial aggressor. It can be contemplated in that sense. as to whether. So it's not what we would say is that it's not a blanket prohibition on any use, but on a specified use specified in the statute, and that does not include whether or not you're the initial aggressor in that situation.
I'd like you to address one more thing before you conclude.
Yes, ma'am.
Assuming that you're moving towards conclusion. Does any privilege change from within the home to the yard? Is it the same privilege? If a person is in their property, being the yard, versus in their property, in their home?
I think under the statute and everything like that, and this wasn't directly litigated, so I'm kind of going off the cuff a little bit.
Well, it was argued at the onset of appellant's argument.
Sure.
Today.
Yes, ma'am. And in terms of that, I mean in brief form. So I don't have the benefit of
Understood.
pulling up a case law and everything. My knee-jerk reaction is that the distinction between the Castle Doctrine and your property has been diluted. You have a legal, it says that you don't have a duty to retreat if you are legally where you're allowed to be.
But I think the distinction is the Castle Doctrine creates a presumption that you acted within self-defense, which the state has to rebut before it gets to disproving all the elements of self-defense. Is that fair?
Yes, sir. And so in terms of the necessity of the use of force, I would agree. Once you're in the yard, and we're kind of getting into a hypothetical here, because at the time that the force is used, both are in a spot where they're legally entitled to be. So I don't think that then there's a presumption
Right.
in that situation. Would it have been different if they're, fully engaged on his front porch? Yes, that's, whether the Castle Doctrine incorporates the curtilage, I would have to look at that a little bit further. So I guess I would say, if I'm being pinned down to it and without further review, I would say that no, it doesn't incorporate the front yard the same as it does the house. This isn't the Wild West. You don't have the right to act with impunity and shoot trespassers and hang cattle rustlers.
Isn't the Castle Doctrine really rooted in the sanctity of the home?
Yes, ma'am. Absolutely.
I don't know if there's any precedent to give that sanctity to the yard.
And I would have to look at it, but I would agree with that assessment.
In fact, there were a couple of cases in other districts which specifically found that the Castle Doctrine is applicable only to the home and does not extend to the yard.
I believe that is correct. As I said before, we're getting a little bit far afield of what I briefed and was prepared for. So I'm acting off the cuff, and I'm always reluctant to say something unless I'm certain of it. But I believe that is correct. And if pinned down and asked to give an opinion, I would say, with that caveat, that is. I'll briefly conclude because I've got to
We
be.
won't hold you to your comments on those questions. How's that?
Fair enough. Thank you, ma'am. This really is a question of credibility. There's a lot of moving pieces here. There are a lot of things issues that have been raised and arguments that have been made. But at the heart of this case, if the jury didn't believe that she made those threats, then all the other arguments go by the wayside. Whether he had a duty to retreat or not, if he didn't have a bona fide belief of imminent physical harm or threat, then he couldn't use self-defense. And we would ask that is the primary focus. I don't think it's necessary to go into a lot of these other things because, at its heart, if the jury didn't believe him, and he gave them plenty of reasons not to believe him, if the jury didn't believe him, then he didn't have a right to use self-defense.
So just for summary, because
Yes, ma'am.
we have students in the courtroom, your argument is that it really comes down to the jury's determination on credibility as to whether he felt that there was an imminent risk of harm enough to support his use of deadly force?
I think that is yes, ma'am, I think that is the overwhelming issue before here, and as the court is well aware, and the students should be made aware, the jury is free to accept or reject anybody's testimony, and simply because they chose to accept the state's version of facts and not his does not make something against the manifest weight of the argument, or manifest weight of the evidence, and we don't believe that that's sufficient to overturn this case.
Thank you. Any other questions from the panel?
Thank you, Your Honor.
Thank you for your argument this morning.
Your Honors, because of what I would label as an improper argument from the prosecution, we don't know if the jury didn't believe Mr. Worth, if it was a credibility issue, or whether or not the jury, because of the arguments made by the prosecutor, whether the jury believed that he was at fault in creating the situation.
So your position is that because of the arguments advanced by the state at the trial court, that tainted the
Absolutely.
proceedings and gave something for the jury to consider, which was not proper for the jury to consider? And that's
Absolutely.
the reason why
The jury very well could, based on the improper argument by the state, the jury could have, we don't even need to look at credibility. We think he was at fault in creating the situation because he went outside, because the prosecutor continually argued, he's inside, there's a door between them, he goes outside, he re-engages, he's at fault, he's the aggressor in this situation.
But I guess I want to pin you down on that, because like that seems to me to be an appropriate argument to say that the defendant is the aggressor. Like the stand your ground law doesn't obliterate that. That's still one of the elements of self-defense and a core element, that you are not at fault for commencing the affray. So what's wrong with saying he was at fault? Like, doesn't the state have to argue that?
And I would submit, how is he at fault when he is on his own property where he
Well, but
has a legal
that
right?
again is the question that the jury has to wrestle with. Like, was he at fault or not? And I think reasonable minds could disagree on that.
I would say with the statute that indicates that you know, if you have you do not have to, you can stand your ground as long as you're in a legal place that you have to be and you don't have a duty to retreat. I would say that covers it at that point in time. Now, if he was somewhere where he didn't have a legal right to be, then you can argue duty to retreat. But because they argued duty to retreat, and in fact, the police officer even opines that he had a greater ability to retreat than she did. How is that not an improper comment on a duty to retreat?
Was there an objection to that?
I don't believe there was an objection to that, Your Honor.
In fact, there was only one instance in which the trial counsel, I'm not even sure it's an objection, more had a discussion about it, correct?
Correct. There was during the mother's testimony, there was a sidebar called, and the defense counsel made an objection to the line of questioning regarding the duty to retreat.
So most of this evidence in the comments and whatever, that was we have to look at that on a plain error basis, correct?
I would submit, yes, that we would still meet the plain error standard, because it's my opinion, a clear deviation from a clear legal standard that have basically affected the substantial rights of Mr. Worth in this case. So I think I still think we make the plain error standard, and in addition, it would go to the effective assistance of counsel, the fact that you're not making objections to what is essentially an argument of that he had a duty to retreat.
Okay, and then also, in this discussion about the duty to retreat and how the trier of fact is not supposed to consider it, but that's shall not consider the possibility of retreat as a factor in determining whether or not the person who used force in self-defense or defense of another reasonably believed that force was necessary. So that doesn't go to whether there is a subjective belief. That is whether it was objectively reasonable.
No, I think it will go to subjective as well, because it's saying that whether that person reasonably believed that force was necessary to prevent injury, loss, or risk to life or safety, I think that would certainly go into their subjective analysis.
Whether it was a bona fide belief?
Yes, yes. Because that's even argued is that they're arguing that he didn't have a bona fide belief because he's moving towards the situation, so he's not afraid, as if you're moving towards a situation that proves that you're not afraid.
Well, that's different than the duty to retreat, correct?
No,
I mean,
think it's
advancing is
I think
different
it's a
than
broad,
retreating, correct?
and that's a good question, because that was brought up at trial, and even now the issue of the right to advance versus a duty to retreat. I would submit to the court that what the prosecuting is asking the court to do is basically create a rule of law that says you don't have the right to advance, which is totally inconsistent with established law, especially all the cases I cited in my reply brief where they say if you're in a place where you legally have the right to be, that's what the question is. Are you allowed to be where you're at? He was on his front yard in his own property. Absolutely. She was where she didn't have a legal right to be. So he's where he has a legal right to be. The court cannot say that that a person does not have a right to move to their front yard, which is all he did. And the act of self-defense does not take place when he's moving towards the front yard. It does not take place when he's standing in his front yard until she lunges onto his property and obviously threatens him. If we're going to say that there's a rule that says you can't advance in a situation, I mean, that's a slippery slope. Well, you can't go certain places because someone might be there that could attack you. You can't if somebody threatens you at this location, you can't go to that location. Otherwise, you're going to be labeled the aggressor. You're going to be deprived of your right to use self-defense. So I think, yes, there is a conflict between this right to advance and a duty to retreat, but I believe that this talk about a right to advance is broader than the duty to retreat. And I don't believe that there should be a rule of law saying that you cannot move towards a situation. The analysis is, are you somewhere where you have a right to be, or are you engaging in conduct that is so, again, not that you have a role in the provocation, but you are engaging in such wrongful conduct that it's provoking this person to attack you. And that wasn't in this case. I think affirming this case is essentially reinstating a duty to retreat and even a broader duty to avoid danger.
Thank you. Unless there's any other questions? All right, thank you for your
Thank you, Your
argument this morning. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Before you both depart, there are students, and if you have availability, you're welcome to be able to have a few minutes to engage with them after the second argument. If you're not available, we fully understand. Just wanted to extend an invitation to both of you.
Yes, ma'am. Thank you.
All right.
Thank you, Your Honor.
We're going to take a quick pause here. All right, good morning. So now we're going to hear the case of State of Ohio versus Dupree. And it's Attorney Hattemeyer. Did I say that correctly? Hattemeyer? Hattemer. Okay, thank you. Attorney Hattemer, if you can come onto the podium. Welcome.
Thank you.
Would you like to reserve some time?
Yes, Your Honor, I'd like to reserve 3 minutes.
All right, whenever you're ready.
May it please the Court, Ms. Ferris? This case is not an assault. At worst, it's disorderly. It should have been a conviction for disorderly conduct for mutual combat. At best, it should have been an acquittal. The basic facts are we have a 20-year-old woman, Ms. Dupree, who has just gone through a breakup and is invited back to the house where she was staying at to retrieve her belongings. So those belongings are placed on the porch in plastic garbage bags. As she's there, sort of gathering up her things, she's immediately accosted by Miss Vernon, her ex-boyfriend's grandmother. Miss Vernon,
When you say accosted, what do you mean by that?
Miss Vernon arrives back as soon as after she's notified that Miss Dupree is there, and she says, "Get off my property, get the fuck off my property." Then she approaches, she I think gets out of the car while it's still moving, that she's riding back in with her friend.
When you say accosted, you mean verbally?
Verbally, and then I think the record shows, and the trial judge said that these were the credible facts, was that Miss Vernon is the first one to touch anything. Miss Vernon throws the garbage bags of Miss Dupree's stuff off the porch. So the trial judge said these are the credible facts. You know, Miss Dupree's things were thrown, then Miss Dupree threw Miss Vernon's purse.
You say Ms. Vernon, you talking about Verna Hudson?
I'm talking about the grandmother.
Houston.
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 I'm sorry, Miss Verna Houston.
Verna Houston, okay.
So Miss Houston, I should say. So Miss Houston throws the garbage bags off the porch. Miss Dupree reacts in response, throwing her purse. And then during this time, Miss Houston tells the ex-boyfriend that Miss Dupree has put hands on her. He comes out of the house, snatches the bonnet off Miss Dupree's head, and runs into the house. The trial court said that none of this activity outside the house is what led to the conviction. The trial court said, after you were told to leave to Miss Dupree, you went into the house, you didn't have a right to be there, and therefore what happened in there is on you. What happened in there, according to the trial court, is that the residents, Miss Houston and the ex-boyfriend, used force against Miss Dupree, and during that exchange, Miss Dupree kicked, and one of those kicks hit Miss Houston. So that's the basis for the assault conviction.
So wait, once she got into the house, somebody else used force on Miss Dupree?
The first thing that happened is she went into the house. It's at split level, so there's a short staircase. Her ex-boyfriend is at the top of the staircase holding her bonnet above her head so she can't get it. She goes to reach for it. He punches her in the face. And this is unrebutted testimony.
And the trial court found that he actually punched her?
What the trial court said about it was that you go into someone's house after they've asked you to leave, then you're upset that they use physical force or they attempt to use physical force to remove you from the house. The only testimony about it was from Ms. Dupree, who said that she was punched in the face and that Ms. Houston was hitting her with the broom.
Well, but, I mean, I know this isn't really squarely addressed by this case, but piggybacking off the prior case, like the Castle Doctrine says, like if you're in your home and someone intrudes into the home, you're presumed to have acted with self-defense. So these two individuals are in their home, there is a trespasser, they're presumed to be acting in self-defense. If she is assaulting them, or if there is mutual combat, or however you want to describe it, it seems like that's more on her at that point.
Yes, Your Honor, it would be if she was trespassing. But that's where the trial court's error is that Ms. Dupree was not trespassing. On the porch, she was told to leave, and during her reasonable opportunity, she was interfered with. But when she went into the house, she was going into the house under privilege.
And what privilege would that be?
In State versus Logston, which is a case about an abortion protester, it's a First District case from 2005. And we have copies if you haven't seen it. So there, an abortion protester, he's a regular protester outside the clinic. He knows he's not welcome on the property. His sign is taken by the clinic director into the clinic. So he follows her into the clinic, confronts her, physically grabs back his sign and leaves. And the First District determined that that was not trespassing because under Restatement 198, he has a privilege to go onto that property to retrieve his personal property that was taken there.
So would you say that it applies the same, in that case, that was commercial property, in this case, it's someone's home? Would you say that any rule of law that comes out of that case applies equally here?
It does, according to the restatement, where the property is taken into the home based on wrongful conduct of the homeowner or wrongful conduct of the third party with the homeowner's knowledge. So here we have two residents. We have the ex-boyfriend and his grandmother. the grandmother sort of brings the ex-boyfriend into the fight by saying that Ms. Dupree had touched her.
And are you saying that it's unrefuted that the bonnet was taken from her by the former boyfriend?
Yes, there's no testimony saying that it wasn't.
So just to make sure I understand what you're advocating for, like say someone takes something from me of little to no monetary value, you know, a book or a pen or something, and I know they took it back to their house. I show up at midnight. I break into the house to retrieve that item. Like, is that all okay? Am I allowed to do that under the restatement rule that you're pointing to?
Under Restatement Comment I, it says the actor's possession was taken as privilege to break and enter. She didn't break and enter here. She followed in immediately after to a home that she just lived in. And I think we don't know the subjective value of the bonnet. She says she's embarrassed to be outside with her hair the way it is, and he probably knew that as her ex-boyfriend. So there may be some differences. I think then maybe you could make a reasonable demand, or you're not there following, so maybe you do call the police in that instance if you want your pen back. But here she's on the porch. He snatches it off her head forcibly. The door's open. She just follows a few steps to get it back and then is physically attacked.
Now, what's interesting is also in this case, the victim is Miss Houston, not her son, right? So how does that play into what your proposition is with regard to she had, let's say that we assume that she had a privilege to go into the home in order to retrieve her bonnet?
I think it plays in two ways. One, Miss Houston and the ex-boyfriend are acting in concert. Miss Houston brought him in by saying, Mr. Dupree laid hands on me, which Miss Houston doesn't testify to that. She said it, but she doesn't testify that that actually happened. So she brought him into the fight. And then secondly, Miss Houston is hitting Mr. Dupree with a broom, so she's part of that fight too. She's not the one who took the property, but she knew that it went there. She knew that it was wrongfully taken there, and then she's hitting Mr. Dupree with a broom. While Mr. Dupree is, I think she testified she's being held by the ex-boyfriend and has her hands up protecting her face. She does say she was kicking at Miss Houston, who was hitting her with the broom. And that testimony about hitting with the broom is also unrebutted. The prosecutor asked two careful questions to the witness, to Miss Houston and to the third-party witness. The third-party witness didn't see what happened inside the house until the kick. Miss Houston was asked, did you ever put your hands on the defendant? She said never. Did you ever kick her things? She said never. She hit her with the broom and grabbed her things. And the other witness, Miss Houston's friend, Miss Radovich, was asked, did you see her kick any of Miss Dupree's belongings? She said no. Did you see Miss Houston put her hands on Mr. Dupree at all? She said no. Then on redirect, the prosecutor strayed from these careful questions and said, did you ever see Miss Houston kick or touch in any kind of aggressive manner her things? Then there was some confusion, and the witness said no, other than picking them up. So I think it's clear that the prosecutor, by asking specifically, did you ever lay your hand on her, did you ever touch her, was avoiding the broom question, and then that came out during Mr. Dupree's testimony. But either way, it appears the trial court did credit this testimony. She said that she believed everybody, essentially. I think she said portions of Mr. Dupree's testimony. But the trial court's decision was that the physical force used by the residents was privileged, and they were allowed to use self-help. But she ignored the fact that Ms. Dupree is also allowed to use self-help to retrieve her bonnet.
So is it your position that in addition to Ms. Dupree being privileged to enter the home, that privilege trumped Ms. Houston's privilege as the homeowner to not want her in the home?
Yes.
Even though the reason, the cause that preceded the entry into the home was not caused by Ms. Houston, was caused by her son?
Yes, it does, because they're both residents. The ex-boyfriend took the bonnet into the home, and Ms. Houston was aware of that. So if we go by the restatement, that's the standard. She's aware that a third party took the bonnet.
And I think, like, where my earlier question was going was, like, is there any limit on the value of whatever the item is, because, I mean, my breaking into someone's house to retrieve a pen seems kind of silly, but if there's not, then I think your rule would allow me to do that. And is that a rule that we want to endorse to allow people to say, like, oh yeah, I think you stole a paperclip from me, I'm going to bring a sledgehammer to your door in the middle of the night?
Yeah, I understand that problem. Under the restatement, you can be liable for unreasonable conduct.
So maybe the sledgehammer would be unreasonable to recover, okay.
But it would also be the timing, right? So what you're saying is that the fact that this just happened, the door was wide open, and she ran in to get the bonnet versus coming back at midnight and breaking it into the house while the people were sleeping
Yeah, yes, exactly, Your Honor. And
The sledgehammer.
with a sledgehammer.
And the restatement, it goes to that a bit by whether use of force is justified against a person. So under comment H, the actor privileged to use force to retake the property from the person if they could on hot pursuit, which those elements would be met here. He forcibly took it. She went in immediately. If this court would find that that Ms. Houston was not part of that, we still would say that she shouldn't have been convicted of assault, that she should have been convicted of disorderly conduct for mutual combat and didn't have the mens rea to be knowingly attempting to cause physical harm to Ms. Houston.
So what you want us to do is find that the trial court erred in determining that she was trespassing. There was mutual combat. And then what do you want us to do? Send it back or find her?
You think that Ms. Dupree should be, that there wasn't sufficient evidence to convict her of assault because the trial court based that on the faulty legal conclusion that she was trespassing.
Okay.
If this court disagrees with that, we also think there's other options. The court could remand for further fact-finding on that, or could reduce it to misdemeanor disorderly conduct based on the mutual combat.
Okay. Unless there's any other questions from the panel? Okay, thank you.
Thank you.
Good morning, Attorney Ferris. How are you?
Good morning. May it please the court, opposing counsel. I'd like to jump right in and discuss the case law that was brought to my attention yesterday. I would, just for the record, like to be clear that that was not in the original briefing, and that yesterday evening was a really last-minute time to get that to me. But I have read the case.
Is this the abortion case that he was
This is the
discussing?
abortion case, the Logsdon. I also read a case that criticized it, Cyril's. And it was readily available in the Lexis. And I think it goes to the commercial property section that you had sort of asked about. So it breaks this torts rule down into two parts. Is the property does have to be placed on the land without the property owner's consent. And the property has to be quickly and easily removable, or peacefully removable, by quick entry and exit onto the land. So I think that goes to a lot of the sledgehammer concerns, and it goes to the commercial property. Because in the abortion case, you have a commercial property, you have somebody who's taken a sign and they've taken it on, and it distinguishes. It's before she's made it back inside the building. So the reason he had to act quickly and could act quickly is that the individual who was legally on the sidewalk that wanted to retrieve his recently just taken property was able to dart on, grab it out of her hands, and dart right back off.
But wasn't that what the defendant here was trying to do, at least?
I'm not really sure what she was trying to do. I will disagree with, perhaps the defendant did say things that, we didn't call rebuttal testimony on, but the judge did say that she found our prosecuting witnesses credible, and she didn't make any distinctions on how credible or what portions. And then with the defendant, she said she only found portions of her testimony credible. She never identified the use of the broom as a portion of the testimony that she found credible. And when she spoke about the bonnet, she spoke about it in this sort of hypothetical way that says, even if the bonnet did make it in there, this doesn't seem like an appropriate or reasonable choice for you to follow it inside and start a physical altercations with the people who live inside.
And is that part of the analysis to determine whether she had the privilege to go in there, as whether it was a reasonable choice?
Well, I think it goes to peaceably.
Okay.
I don't think that she could have had a good faith belief that this was going to be a peaceable interaction. So prior to that, we're on a small porch that's been described as too small for two people to be, I'm sure we can kind of all picture that concrete slab that is custom in a builder's situation. I wish they would have described for the record what hand motions she'd made, but we didn't get that. And we do have, and I appreciate Judge Trotter-Bratton for being so specific. Let me pull up my brief. She was very specific about what she found to be credible. She said she believed that Houston had told Dupree to leave. She believed that Dupree had ignored Houston, that Houston had attempted to grab Dupree's bag so that she could get by and get into her own house on a small porch, that Dupree threw Houston's purse into the yard, and then she audaciously went into the Houston's home despite numerous commands to leave. And by her own admission, then Dupree ended up kicking Houston. So
it sounds like the trial court found that the right of the homeowner was very paramount here.
yes, she did, and she didn't find any privilege of any kind.
This case with regard to the abortion clinic, when was that released?
The abortion clinic case was in 2005. The criticism of it, Searles, was for 2019.
So that case was available at the time that this was before the trial court?
Absolutely.
And was any of this argued before the trial court?
It was not.
So should we be considering it?
No, we should not.
And why is that?
It wasn't brought up at any time. It's just not we didn't have the opportunity to submit any evidence to the contrary or address these arguments. We didn't have a chance to brief them at the appeals level either. The state has been too prejudiced to be able to respond to these arguments at this stage.
Well, you just responded.
I'm
Quite
happy
well,
to
I
do
might
so.
add.
I appreciate that. I'm happy to do so, especially since we have so many students in the back and as an academic exercise. But in terms of whether or not this is a standard we should hold people to in an appeals situation, I do think that's an important standard. But I also do want to answer the court's questions, and I was also happy to submit on briefs, so I didn't have a lot else to talk about besides my brief. With that, I think that the majority of the argument here calls for this court to overturn very direct conclusions of credibility that the trial court, who is the trier of fact and in the best position to make those determinations, made.
It sounds like there's two arguments being made by the appellant. One is that the law was not properly applied in this case.
Yes.
And then if you go to the briefs, there's also credibility argument that hasn't really been that fully addressed at this point, probably because of time. But let's go to the argument that was focused on today. Let's say we were to agree with the appellant on that legal standard was not properly applied and things that should have been considered, or should not have been considered were improperly considered. What would be the outcome of that? What would we do?
That's a great question. So I don't think we could overturn it based on law that wasn't argued. So the state argued good law and a path to find assault, and the defense didn't argue any of these issues. So even though that the appellant may have found a path that could have been successful at the trial court, based off a cold record and months of thinking about it, I don't think that they have found a path that eliminates our path. We were successful in our path. It's still a valid path to be successful. So the fact that they may have identified a better trial court strategy or a better argument of law now, I don't think negates the fact that we had a valid argument of the law and that the trial court found a valid path to find for assault.
Okay, understood. And then also, as you said before, then didn't provide you the opportunity.
And it did not
to
provide us the
respond
opportunity to respond.
at that time.
So we were prejudiced.
Yeah.
Thank you.
Is there anything further you'd like to add?
I don't believe so. I do think that you would have to overturn the determinations of credibility from the trial court to overturn this, and I don't think that that's the appropriate resolution for this case.
Thank you. So unless there's any other arguments, all right, thank you for your
Thank you.
argument. Any other questions?
Your Honors, we hope you won't hold it against our client that we didn't have that case at our attention before. But I should say that the trial.
Well, but I think it's not just the case. It's like that's a different theory of defense that if it were presented to the trial court, the state might have had responses from an evidentiary basis, not just from I found a better case or something like that. So, I mean, it goes to how the case was presented at the trial court.
Your Honor, respectfully, I think that the trial court is the one who brought up trespass. The trial court said trespass is what was the hinge of the decision, and the trial court is the one who made the distinction between the inside activities at the home and the outside activities, which is why we're here arguing this today. And in our brief, I should say that in the original brief, we talk about the reasons that she went back inside were reasonable because she went back to get her bonnet that was taken off her head, which this cuts both ways. On the one hand, the trial court was wrong in concluding that she was a trespasser and in basing the assault conviction on that conclusion. And secondly, the trial court lost its way by focusing on that when it didn't adequately take into account whether Mr. Pre had a reasonable opportunity to leave. If Ms. Houston is throwing her things, if the ex-boyfriend is taking her hat and bonnet into the house. I think that's part of it. And I would say that the Searles case is completely different here. In Searles, that was an ex-boyfriend, Searles, who was sort of obstinately remaining in a home after he was told to leave because he couldn't find his wallet, is what he said, which he brought there with his consent. So the biggest distinction from Searles is consent, and that's why that court didn't apply the restatement or Logsdon. They also did say peaceably, which I agree with your question, Judge Bergeron, which is that she went in peaceably, just then she was punched and hit with a broom. And it doesn't seem right that their legal right to use self-help to eject her from her home when she's not yet trespassing, she's not trespassing when she goes in.
Is it unrebutted or
Trumps.
conceded that she went in peacefully?
I don't think there's anyone who testified about why she went into the home or how she went into the home, except for Mr. Pre. Ms. Houston testifies that she went into the home.
But they were fighting on the porch. I mean, she threw a purse in the yard.
What the trial court found was that Ms. Houston threw her things, she threw Ms.
Right,
Houston.
so there was a fight going on the porch.
So
So I don't know about going peacefully into the house.
I guess a fight extended into the
Right.
house is maybe a better way of putting that. But if you look at the restatement, she does have the privilege to go in because her hat was wrongfully taken in there, whether it's peacefully or not. Because she's going in on hot pursuit after her property. She can even use force against the person who took the property or the people who took the property.
But that just goes back to the standard of, like, what's the standard then? It can't be a blanket, she could just go get her hat or her bonnet, right? There has to be some standard that allows her to go in there. Is it reasonableness? What is it?
And like, there's got to be some limitation on like the physicality of the confrontation. Like, again, if someone steals my pen, I'm not privileged, I don't think, to like pummel them because they did that.
Yeah, yes, Your Honor. Restatement 198 refers back to Restatement 100 through 110. I think that's the hot pursuit section. So there's a section there about it using excessive force. She's only privileged to use the force necessary to get back her property, which here is going in, trying to just take it, then getting punched and hit with a broom, and I guess kicking on the way out. I think that seems reasonable under the circumstances.
Isn't your proposition trump then the Castle Doctrine?
They're competing rights. I think it's to go back to the other case. They both had a legal right to be there, so I don't see why their right to, because they only had the right to use force if they're ejecting a trespasser. If she has a legal
The
right to be
castle
there,
doctrine
they
is
can.
more than giving someone a right. It's giving a superior right to the person who is on their property that is unwelcomed onto the property. And in this case, I don't think that there's any issue as to whether your client was welcomed or unwelcomed. I think it's clear that she's unwelcomed.
Yes, unwelcome, but not trespassing. And I don't know the
Which then
castle
goes
doctrine
back-
as
which
well
goes
as you all
back-
do, but.
Yeah, then it goes back to the castle doctrine.
But I'm sure that the castle doctrine requires the person to be trespassing, which here she's not trespassing because she's privileged to go get the bonnet. And the bonnet may have had a very high subjective value. She said she's embarrassed to be in public with her hair in the state that it was before. She's a black woman and she's actually involved in, I believe she's involved in like beauty, like that's her job is hair care and beauty. So that's more like leaving somebody to leave the house without a shirt than, you know, a minimal item of property. I would just say to close that we do think this is significantly different than Cyril's. It's closer to Logsdon, except for that her attempt to retrieve it peaceably was interrupted with force. And to the extent that it wasn't reasonable to expect that it would to be peaceably, because her bonnet was stolen from her physically by the residents, they gave up that privilege to protect their dwelling against it. They're essentially, the ex-boyfriend is inviting her in by snatching her bonnet and going in. So we'd ask that this court discharge or at minimum, reduce to minor misdemeanor disorderly conduct.
All right, thank you for your
Thank you.
arguments this morning. Give me a moment. All right, thank you for your arguments this morning. We're going to take the matter into submission, issue a timely decision. As you know, there's students in the courtroom. You're both welcome to stay and to meet the students and share a little bit about what you do, okay? And if you're not available, we fully understand as well, okay? Regardless, we wish you both a wonderful afternoon, or all three of you a wonderful afternoon. And that concludes our arguments today. Thank you, Karen. Let's go.